Nyamira has been conducting their affairs using the 2/3 of the MCAs that remained. So it is my argument, honorable senators and Mr. Speaker, sir, that you do agree with us that the use of the word all, both in the Constitution and in the County Governments Act, was contemplating and expecting the use of the people in office, short of which it would mean that the county assemblies and probably the Senate for that matter and probably the National Assembly cannot conduct some affairs until when vacancies arise in the body of the membership. It is also our argument, Mr. Speaker, sir, that to the extent to which it will be necessary to determine whether it was intended that 2/3 is an absolute figure from the total number of the elected MCAs, number one. Number two, whether the IBC's notice is to be treated as an absolute, as casting the total in stone. Those two questions are questions of fact, Mr. Speaker, sir, and honorable senators, and it is our argument that you should allow this issue to go into full hearing and a determination be made on that issue. Mr. Speaker, sir, I would like then to move on to the issue of proxies. My learned friend has said that the letters upon which the people who exercise voting rights on behalf of others were not produced in the Assembly. Mr. Speaker, sir, in our disclosure, in our documents, we've shown the letters by which the powers were delegated to some individuals to vote on behalf of others. Now, my learned friend's argument was that you should take it for a fact that indeed those letters were not at the Assembly. It is my argument, Mr. Speaker, sir, and honorable senators, that to the extent that you will need to determine whether indeed those letters were there is a question of fact, and therefore we should go to full trial. Secondly, Mr. Speaker, sir, my learned friend has argued extensively saying there is no provision for use of proxies. Mr. Speaker, sir, and honorable senators, I pray that right away you take judicial notice of the fact that you yourself, as a Senate Assembly, use proxies. And therefore, to the extent that the Senate uses proxies as a means of determining its affairs, it be treated that use of proxies is a normal process of legislative processes, and therefore the fact that it has been used in Nyamira is not necessarily wrong, considering that it has been used in this. And Mr. Speaker, sir, I would just want to invite you to the fact that the Nyamira County Assembly has previously used the proxies, and we would like to have an opportunity to adduce evidence to that effect when we come to the full hearing. Mr. Speaker, sir, Standing Order number 67, my learned friend said that I will not be able to refer to it. Standing Order number 67 of the County Assembly, of the Nyamira County Assembly Standing Orders provides for 3 means of voting. That is secret voting, roll call voting, and electronic voting. Now, roll call voting and electronic voting is extensively described in the Standing Orders. The secret ballot voting system is not extensively explained in the Standing Orders. And that therefore leaves room for the Speaker to use Standing Order number 1 and give guidance. In the specific case of this voting, which is the subject of the impeachment that has been placed before you for determination, the issue of the use of the proxy was presented to the Speaker. The Speaker was invited to the fact that some people have sent authorities authorizing and giving proxies powers to vote on their behalf. Those documents were produced, therein they answered. And Mr. Speaker, sir, the Speaker of the County Assembly, in exercise of his authority under Standing Order number 1, authorized the use of the proxies. And therefore, Mr. Speaker, sir, it is our argument that that process was, use of the proxy was properly considered, evaluated, and determined, and that it is properly allowed by Standing Order Number 1 and Standing Order Number 67. Mr. Speaker, sir, I would like to cede the remainder of my minutes to my learned friend, Mr. Mokua, on the two preliminary issues.
Thank you, Mr. Speaker, sir, and honorable senators. For record purposes, my name is Mr. Mokua Ndubi. Mr. Speaker, sir, in determining this preliminary objection by the governor's side, we urge this Senate to be guided by the elements of a preliminary objection as espoused in the most celebrated case of Mukisa Biscuit. Mr. Speaker, you will agree with us that this particular preliminary objection fails all the three tests that was set out in that very old case. First of all, Mr. Speaker, sir, a preliminary objection is supposed to be purely on a question of law. Mr. Speaker, wherever there are questions of facts to be interrogated, then a preliminary objection ought to fail, as is the case before the Senate. Mr. Speaker, there is a contestation as to the exact number of the MCAs in Nyamira as at 25th November 2025, when this impeachment motion was taken. On the governor's side, they are contending that the MCAs in Nyamira were 35 in number. On the assembly side, we are contending that the total number of MCAs were 32 in number. Therefore, Mr. Speaker, there is a contested question of fact, even on the baseline, on the total number of MCAs that were present in Nyamira County Assembly, as that preliminary objection does not meet the second element in the Mukisa Biscuit, is that a preliminary objection is raised and argued on the assumption that all the facts that have been raised by the other side are correct. Mr. Speaker, the governor has filed an affidavit together with his witnesses. This therefore means he is contesting the factual issues that have been raised by the county assembly. To that extent, Mr. Speaker, the matter has to go for full trial so that the senators can make their own independent determination on the factual issues that are being contested. Mr. Speaker, in the Kericho 1 impeachment, there was general consensus, both by the governor's side and the assembly, that the total number of MCAs were 47 and that those who voted were 31. So what was left for the Senate was to determine the threshold, whether it is 31 or 32. And that impeachment collapsed at that juncture. But in Kericho 2, there were contested factual issues, and that is why the matter had to go for full trial, and then eventually the senators had to rule on the issue of the threshold. Mr. Speaker, it is our submission that the position in Kericho impeachment 2 is the one that is obtaining in the present impeachment proceedings. There are highly contested issues of fact which cannot be determined summarily at this preliminary point. Very finally, on the third limb as to why this particular PO ought to collapse, Mr. Speaker, a preliminary objection ought not to be raised where issues of discretion are to be determined. Mr. Speaker, sir, the Nyamira County Assembly standing orders, especially standing order number 1, vests power upon the Speaker to exercise discretion and to rule on procedural aspects which have not been expressly provided for in the standing orders. To this extent, Mr. Speaker, to the extent that the governor's side is challenging the Speaker's exercise of his discretion to allow voting by proxy, the preliminary objection ought to collapse on that ground. Mr. Speaker, counsel for the governor has indicated that these particular 4 MCAs never delegated their power to vote. On our end, it is our case that they did delegate. Sincerely speaking, Mr. Speaker, at this juncture, how can a tribunal or a Senate sitting at this juncture, how can it believe the governor's side and fail to believe our side merely because you are being told affidavits have been filed? Mr. Speaker, if we are allowed to proceed for full trial, we will bring for you a phone where this particular one of the MCAs did send a letter on WhatsApp. We will provide the phone in its original form. We will also provide email correspondence by these particular MCAs who are alleging that they never allowed to be voted for by way of proxy. Mr. Speaker, under the doctrine of silence of laws, where an act of parliament is silent on a particular item, then generally that particular act of parliament does not provide for a certain action, and at the same time, it does not prohibit a certain action. To the extent that the Nyamira County Assembly standing orders are silent on the aspect of proxy voting, they do not prohibit and neither they do not provide for. So the general provision of law is that act of parliament is silent on any particular item, that particular action is allowed. It is therefore our case, Mr. Speaker, that voting by proxy is allowed under the Nyamira County Assembly standing orders. Very finally, Mr. Speaker, a calculation of 2/3 of 32 translates to 71.875. It is our case that the 2/3 threshold was not just met, it was in fact surpassed. This, Mr. Speaker, we can only demonstrate once we proceed for full trial. On the second limb, Mr. Speaker, of the issue of summoning the clerk and the Speaker of the Nyamira County Assembly, we pray if our colleague can drop that particular request. We do undertake to avail one witness, the one who was given the 4 documents. He will avail the documents. He will also avail his mobile phone, and he will also avail the email to which this particular document was sent to him. Mr. Speaker, sir, we do pray that you dismiss this particular preliminary objection, allow this matter to proceed for full trial so that the whole world can be able to see the atrocities that have been committed on the people of Nyamira County by His Excellency the Governor, Amos Nyaribo. Mr. Speaker, sir, we humbly pray that you dismiss this preliminary objection in the alternative, determine on the PO as their first issue. We humbly submit. Thank you.
Now, Honorable Senators, pursuant to Standing Order 34, 2A, I will allow later interruption of the proceedings at 1:15 to allow a rejoinder from the team of the Governor, and thereafter allow Honorable Senators, if you would wish to seek clarifications or ask questions to any of the parties present. Counsel for Governor, you may proceed with your rejoinder.
Thank you, Mr. Speaker, sir.
5 minutes.
Mr. Speaker, sir, with your permission, I had reserved 3 minutes.
Okay.
For my yes. Thank you.
Those are 8 minutes.
I will use 3 minutes, then my learned friend will proceed. Mr. Speaker, sir, pleadings in respect of this impeachment were closed on 1st of December 2025. All parties were required to file their respective document as at close of business on 1st of December 2025. There has been no attempt by the County Assembly to respond by way of affidavits, controverting the affidavits that are on record by the 4 MCAs. None. They had that opportunity, they did not do it. And therefore, in respect of that piece of evidence, it is uncontroverted. That is the position. That is a fact that has been admitted because they had the opportunity to file their own affidavits to respond to this issue. They have not. And therefore, we are squarely within the... Secondly, and lastly, Learned Counsel has sought to seek refuge under Standing Order number 1 of the County Assembly of Kericho. Let me remind him what the Constitution states at Article 181. that Parliament shall enact legislation providing for the procedure of removal of a county governor on any of the grounds specified in Clause 1. Pursuant to that power, this House enacted, which, in case Landed Council has not read, states as follows: except as otherwise provided by this Constitution, this Act, the County Governments Act, or in any other legislation, any question proposed for decision by the County Assembly shall be determined by a majority of the members of the County Assembly present and voting. Can you be present in absentia? It's an oxymoron. When he runs and seeks refuge at Standing Order number 1, standing procedure, therefore the Speaker cannot run and innovate when there is a clear provision of the law. Thank you, my learned friend.
Mr. Speaker, thank you. For the record, my name is Zelma Bunuke, Counsel for the Governor. I'll address the issues that have been referred to by the other side of the County Assembly. I've heard them urge the issue of Kericho and how the proceedings of this House were concluded. It will be noted and on record that upon the proceedings being terminated, the Senate resolved to vote on the PO first before delving into the other grounds. What then does that mean, Honorable Senators? We do not have to waste time on an illegality at this space. As my colleague said, the Honorable Senators have a lot to do, and we have highlighted a significant point or question of law on the threshold. Let me take you through what constitutes of the Nyamira County Assembly. It has got 20 elected members, 11 of which form the part of the gender top-up, 4 in the marginalized category. That is 35. Nothing changes. I will put contexture to that while referring to the Constitution of Kenya under Article 138 on the election of the President. Allow me, Honorable Senators, to refer to Article 138, 4A, which says, in a presidential election, a candidate shall be declared elected as a president if the candidate receives A, more than half of all the votes cast in the election, and at least 25% of the votes cast in each of more than half of the counties. Honorable Senators, we have 47 counties in Kenya. Half of that, my quick math tells me that is 24. Therefore, the express provision of this, of the Constitution, is that we cannot then say that if 38 counties voted, then they did not meet the threshold, because the law is clear that they have to be more than half of it. So what you're being told here is that we need to subtract the members who are not present and then lay the basis of having the 2/3. Allow me to refer to the Constitution once again on the process of the removal of a governor. It's very clear. It is not something that has been created out of anything else, but it's in the Constitution. The framers of the Constitution were very specific under Article 33(1), and I will read Article 33(2). Sorry, this is the County Government Act, Section 33(2). It is specific that a motion under subsection 1 is supported by at least 2/3 of the members of the County Assembly. This, honorable members, is a specific motion. It is not a bill or any other motion that can be brought to the House. It is particular to the removal of a governor. We do submit, honorable senators, that even if the County Assembly Speaker sought to create his own rules on how to conduct this voting exercise, then the standing order number 1, which they have sought to rely, is very specific, and they have read selectively standing order number 1(1). What they didn't tell you is that standing order number 1(2) provides as follows: the decision made in paragraph 1 shall be based on the Constitution of Kenya, statutes of law, and the usage of forms, precedents, custom, procedures, traditions of the County Assembly of Nyamira, the County Assembly, and the Republic of Kenya within this jurisdiction. They have failed to refer you to any statute that provides for proxy. You have also been told that this is a norm at the County Assembly of Nyamira to use proxy voting. Then we pose this question, Honorable Senators. Should we then countenance an illegality on the face of it, which has these serious ramifications, including impeaching an elected governor on a basis that does not exist in law? Honorable Senators, we urge you to consider our preliminary objection, and especially on this point on the threshold. If you are told that the issue of proxy have to be called as witnesses, that is fine. But then have we determined the first question on whether this motion met the threshold? The answer is a resounding no. We yield to that, Honorable Senators. Thank you.
Now, Honorable Senators, we have 6 minutes. Kindly shoot straight so that we can extract the most out of these 6 minutes. Senator for Nairobi City County.
Honorable Speaker, very interesting arguments have been made about membership, and I want to seek clarification from Council, especially Council for the Governor. On the question of membership, you have stated very well what Section 33(2) speaks about, that motion has to be supported by 2/3 of all the members of the Assembly. I want you to tie that to the provisions of Article 103(1)(a) on vacation of office. Upon the death of somebody, can that person be still referred to as a member of the Assembly for purposes of determination of membership? And therefore, Speaker, there is a very interesting point that was raised by Council for the Assembly. For instance, Speaker, if by catastrophe we have 35 members in the Assembly, 15 of them are in a bus, and the bus plunges into a river and they are no longer members of the Assembly. If an issue of impeachment were to arise in determining 2/3 of those members of the Assembly, is it the case for the Governor that we will still use the number that was determined at the election in August of 2022? Thank you, Honorable Speaker.
There's Counsel for Governor.
Thank you, Mr. Speaker, sir, and thank you, Senator for Nairobi, for that question. My straight answer to that question is the impeachment process is governed by 3 pieces of legal provisions: Article 181, Section 33, and the standing orders. It does not anticipate a scenario whereby there will be a vacant that will have to last for so much, or rather for so long, such as to affect the business of the House. And let me just give this as an example. Assume that for a moment, half of the House is not present, either by tragedy or disaster. What happens to that House? Do we then reduce the threshold to the remaining 10 or 5? We cannot do that. So if there is a vacancy, it does not affect the threshold because the law has a mechanism of filling that vacancy. That would be my short answer to that issue. Thank you.
Senator Wambua.
Mr. Speaker, I have a similar question, but this time to the Counsel for the Assembly, Katwa Keegan. Mr. Speaker, I want the lawyer to address me and address this House on the question of the membership of any assembly. At what point does that membership determine? Does it determine immediately after elections and after political parties have had an opportunity to discharge their obligation to nominate members? Or is it a moving target? Is it one number today, a different number tomorrow, a different number next week? At what point does this number determine. I thank you, Chair.
The Counsel for the County Assembly.
Thank you, Mr. Speaker, sir. It is the direct answer to the question from us is that it is a moving target. The reality of it is that at every given time, the representation has to continue. Various activities have to be done. There is need to approve budgets, there is need to determine issues, and therefore the fact that there is a continuous need to attend to issues on behalf of the public makes it a moving target. And at every given time, the people who are available to transact the business on behalf of the people who elected them is the determining factor of the total bottom line number of people who are to vote. That's my answer to the question.
Senator Boni.
Mr. Speaker, I'm convinced by what the Counsel for the Governor Mutuma has said, that voting by proxy, you can't find it anywhere in the standing orders of the County Assembly or anywhere else. And yet, this is going to guide us to decide on your PO, Mr. Mutuma. Don't you think reading standing order in its entirety, we should give the County Assembly an opportunity to demonstrate to the House that the Speaker proceeded under standing order number 1 of the County Assembly, allowed by proxy, and maybe he did so because of some usage, some tradition that preceded that decision. Don't you think we should allow this to proceed so that we hear evidence to make a decision instead of just condemning them? No, you are wrong.
Counsel for Governor, you have a few seconds to respond.
Thank you, Senator Boni Halwale. An argument based on points of law or the interpretation of law cannot be a factual issue. It is based on legal arguments. They had that opportunity to submit, and that's why this Senate directed us to prepare written submissions and bring them before this House. That is why they've been given 20 minutes to demonstrate to you through legal arguments how the Speaker can rely on standing order number 1. There is no witness who is coming to testify on a question of law. It is purely an interpretation issue which does not require evidential interrogation. The purpose of going through a trial, honorable senators, is for you to look at the facts, to cross-examine the witnesses on their version of factual issues, and then render a decision of fact. Questions of law.
Counsel for Governor, time
Thank
is
you.
up.
Thank you.
Now,
Thank you,
Honorable
Mr.
Senators, I will be giving my ruling at 2:30 on this particular matter. All right. Now, Honorable Senators, it is now 1:15 p.m., time to adjourn the Senate. The Senate, therefore, stands adjourned until later today, Wednesday, 3rd of December, 2025, at 2:30 p.m.